My name is Charles Raab from the University of Edinburgh, and I'm delighted to be here and chairing this panel along with Eva Szekely at the other end, who will be the moderator of the panel. This is the panel on data protection authorities, their role in experience and enforcement. And there's a history behind a panel on data protection authorities, which Ivan and I have run. This is now the third year. 2 years ago, we ran a panel on data protection authorities and how independent they are and what are the factors relating to independence. Last year, we did one on DPAs and their cooperation and arrangements among each other, mutual assistance, and so on. And you can see that these are both very topical and very important issues, particularly in the European legislative context and in the European dialogue about the future. And this year, this panel is on data protection authorities and their role in enforcement. And that's particularly timely in the European context as well, because in the proposed regulation, enforcement takes on a new kind of configuration, enforcement by data protection authorities. If you look, for example, at Articles 51, 52, 53, whether in the original form of 2 years ago or in the modified and supposedly agreed form of late last autumn, there are various duties that are laid upon data protection authorities in terms of enforcement, and there are also some powers that they have, and these powers can be quite broad and wide-ranging, having to do with powers to enforce compliance and to levy severe financial penalties, to order the rectification and erasure and the destruction of data, to impose bans on processing, and so on. You can read those in those articles. But of course, the enforcement of data protection law depends not so much on what the law says, or not only on what the law says, but on the resources and the opportunities and the political circumstances, indeed, and the decisions and the proclivities, if that's not too fancy a word in English, of how and when to act and to be strategic or tactical in doing that kind of enforcement. And up to now, the national efforts across Europe in data protection law enforcement have been fairly varied, because the powers and the resources and the inclinations of the different DPAs have differed. This will be changed once the regulation, if the regulation comes in. But what we're focusing on today is, and that was just to set the scene for what we're focusing on today, which is how have DPAs performed so far with regard to their role in enforcement. And also, if we look away from Europe, or if we look to the USA, where there is nothing like a data protection authority, how has an organization like the FTC performed in this field of enforcement? And we have an excellent panel today who will address these issues. Rather than read through who they are and so on, we have, Ivan has prepared the slide up there, and the panelists are going to address several questions. How have DPAs performed their role? What are the constraints and opportunities? How have data controllers complied with decisions and regulations of DPAs? And the fourth one is, what's going to happen in reality following the adoption of the regulation? And the speakers, in order of presentation, will be, first of all, Billy Hawkes, who is the Irish Data Protection Commissioner. And if you look on the speakers page online, you can find his brief biography. Then Eva Souhrada-Kirchmayer, who was in the Austrian Data Protection Commission as an executive member, and she is now working as a judge in Austria at the Federal Administrative Tribunal, and she is also the Data Protection Commissioner of the Council of Europe, but she's speaking in an Austrian perspective today. And then Sophie Louveaux, who is head of Supervision and Enforcement Unit at the European Data Protection Supervisor, the EDPS, and responsible for monitoring and ensuring compliance with the existing regulation in the EU institutions and other bodies. And then the last speaker will be Bob Gellman, who is a privacy and information policy consultant in Washington, D.C., who advises companies and lots of other organizations on data protection and privacy matters. He has had a long career, in part as being the staff member of the subcommittee of the House of Representatives responsible for privacy, freedom of information, and more. So without further ado, I would like to call Billy Hawkes to give his presentation. Thank you.
Thank you very much, Charles, and good morning, everybody. I think we need, first of all, in looking at this topic, to define what we mean by enforcement. For me, it means ensuring that organizations under our supervision, as a minimum, comply with their legal obligations towards individuals, and ideally go beyond that by following a best practice approach. Now, in order to achieve this objective, we're given a variety of tools as data protection authorities. The toolbox is not the same in different European member states. In the Irish context, we are provided with a range of what you might describe as soft and hard enforcement tools. Now, in the soft category, I would put guidance provided to organizations through our website, presentations, and responses to specific inquiries, and we devote significant resources to this guidance function. In the hard category, I would put the power to issue legally binding enforcement notices to organizations, which can go as far as ordering them to cease all processing of personal data, and the power to bring them before the courts if they fail to comply. I might add that a multinational company under our jurisdiction is currently subject to such a cease order and will not be allowed recommence processing until we are satisfied they have adequate security in place. I would also include in the hard category the power to bring named managers and directors to courts if the initial prosecution of the company does not achieve the desired results. I would also include in the hard category our power to ensure that complaints are thoroughly investigated by giving us the full power to require access to all relevant data and personnel. Now, in a sort of in-between category, I would put our power to carry out audits of organizations without their consent. And that power includes the power to conduct dawn raids if we suspect that evidence might be destroyed or organizations are not otherwise cooperating. Now, our general experience is that organizations wish to cooperate with us and that we can usually achieve compliance with the law, in fact, and going beyond that, best practice, without using coercive powers, the hard powers. I think organizations generally recognize it is not in their interests to provoke coercive enforcement action, and not least because it's terrible public relations for the company or any other organization. We do not have the power at present to directly impose fines. It's not something that has seriously inhibited our activities, since our other powers I've mentioned, such as the power of compulsory audit and the power of enforcement, are extremely strong and effective, and I would argue, in fact, are far more effective than any power to impose fines. Now, turning to the situation under the proposed EU regulation, we will have the power under that regulation and indeed sometimes the obligation to impose fines. Under the regulation, we will also be cooperating even more closely with our other European data protection colleagues under the so-called one-stop shop arrangement and the consistency mechanism, which is an integral part of the arrangement. Now, we've already been doing so in relation to our audits of multinationals like Facebook and LinkedIn. We've taken account in those audits of issues raised by colleagues, and we reported back regularly to our colleagues in the Article 29 Working Party on how matters were progressing and how we were taking account of their concerns in the conclusions of those audits. Now, under the regulation, we'll be looking forward to similar cooperation from our colleagues in relation to European multinationals. Now, European multinationals are significant providers of services to Irish residents in areas such as telecommunications and banking. And under the regulation, we will lose our current authority to take action against their Irish subsidiaries. For example, we regularly have the telecommunications companies before our courts for breaches of the electronic privacy regulations in relation to sending unsolicited marketing. And in fact, in one case, we've reached the stage of telling them that if there's a further offence, we will actually be prosecuting their directors and managers. So in summary, while the regulation will bring challenges, we're gearing up to deal with them. And in the meantime, we're continuing the enforcement cooperation we have both with our European data protection colleagues and also key enforcers outside the European Union, such as the US Federal Trade Commission and the Canadian Privacy Commissioner. We have memoranda of understanding with both of those organizations in order to facilitate cooperation, including exchange of information. We'll also be hoping in the future for further development of multilateral cooperation under mechanisms such as GPAN, that's the Global Privacy Enforcement Network. So, as I said, we are looking forward to the new situation under the regulation. I personally support the regulation, the idea that there will be a single law applying across the European Union, the idea that a company would have to deal with only one regulator, but that regulator would be tightly bound by the obligation to cooperate with other regulators through the consistency mechanism. So thank you very much, Charles.
Thank you very much, Billy, not especially, but also for keeping very well on time. Yvonne would like now to pose a question.
Yes, I think now this is a very brief turn for the moderator. I would have a question to Billy, but before asking the question, I would like to turn to the audience. I will still keep the mic, so it's not the proper time for your questions and comments, but I would like to know your idea about the different sets of powers which Billy Hawkes mentioned he has in his position, an interesting combination of soft and strong powers. So I would like to ask your idea on which one is better? Which one would you prefer? A strong authority-like DPA or a weak, so to say, ombudsman-like DPA? So please raise your hands who would prefer the strong authority like DPA. Yes, thank you. And who would prefer a kind of ombudsman type DPA? A minority? Abstained, perhaps? Someone? Okay, perhaps you don't like DPAs at all, but okay, the reality is more complicated. So the soft and hard powers are generally combined, as in the case of the Irish Commissioner. My question to you is, have you identified any specificities any patterns in the compliance or non-compliance of Irish data controllers? It's a small country with a special data protection agencies, or you think that data controllers are all the same everywhere? So are there Irish specificities in this?
Yes, I would say so. In general, I would say that indigenous, if you can make the distinction these days, companies in Ireland are less good at compliance, and we both find Irish people complaining more about them and us being obliged to take more action against them. As a very general statement, and I stress it's very general, in the case of the multinational companies under our jurisdiction, particularly the American ones, we do find a general anxiety to comply and be seen to comply with the law, when, again, partly it reflects the cultural background they come to. And I suppose the paradox for me is that Irish people, for whatever reason, hardly ever complain about these companies. So my inbox in terms of Facebook or LinkedIn is all from outside of Ireland, practically. And the complaints we do receive are against, if you like, indigenous primarily companies like banks, supermarkets, schools, or to the extent they're multinationals, they're the European multinationals who provide services like banking and telecommunications. So, as I said, whereas I stress I favour the regulation and one-stop shop, if I were to be totally selfish, it's a disaster, because I acquire, if you like, sole lead authority jurisdiction for companies that Irish people don't care about, which are the Facebooks and so on, and I lose jurisdiction over the multinationals they do care about, which are telcos, banks, and so on. So I think that will be my answer in terms of our practical experience of how we see things in terms of the complaints we receive, in terms of how responsive companies are.
Thank you.
Thank you. If I may have a very, very brief supplementary to that, when the new regulation comes in, how well equipped do you think your office, with its resources and staff, will be without major expansion?
I think one advantage we have over many other DPAs is that we do not have to deal with many procedural requirements imposed on data controllers, like prior approval of different things. So we're quite flexible in how we deploy our resources. Now, the government have recognised that with all of these multinationals setting up in Ireland, which for reasons nothing to do with data protection, I might add, that in fact we have a responsibility to regulate them and to be seen to regulate them. So our resources have been increased by about a third in the last year, both in terms of staff and in terms of money. Certainly, I think they will have to expand further, but we're currently examining, in fact, the optimum mix of using our, if you like, in-house resources and hired-in resources, because we have the possibility to engage people from outside our DPA where we need particular expertise. And we used that, for example, when we were carrying out the audit of Facebook Ireland. So we're examining different models of effective oversight, particularly of multinationals. But basically, any multinational that declares it's going to establish in Ireland, we immediately tell them, you are going to be subjected to a detailed audit by us, as we want to know exactly how you're processing personal data. We will explain to you our expectations in terms of compliance with the law. We will oblige you using our powers if we have to, but it's in your interest not to oblige us to use powers, so kindly do it politely, based on a polite request rather than being forced to do it. I think we will probably need expansion both of our own staff and also of bought-in expertise going into the future. But I'm confident, in fact, that we already have the experience of doing some of these detailed audits, of dealing with the complaints who are coming in. So I'm confident, in fact, that we will be able to handle this burden. For example, we've already programmed 3 audits of major multinationals which have set up in our jurisdiction, and those will take place this year, and we're currently scoping out what mix of in-house and external resources we'll be doing. So it certainly makes my life far more complicated. I used to have a relatively quiet life when I was appointed first in 2005. Sadly, that's a history and a pleasant memory.
Thank you. So there's no time to sit back and sip your Tullamore Dew or Jameson's and so on. I'd like to turn next to Eva Souhrada-Kirchmayer from Austria. Her brief biography is up behind, so you can have a look. Eva, would you like to come up here, or do you want to sit there? Either way is fine.
No problem.
Okay.
So good morning, ladies and gentlemen, and thank you for the kind invitation. My remarks refer to a small DPA in a small member state with limited powers and especially with limited resources. And so I have some experience in the Austrian DPA. I want also to inform you that the Austrian DPA the Data Protection Commission was dissolved by the end of last year. It was replaced by a new Data Protection Authority, but it were not the powers that changed, only the organization changed. That means that the Commission was transformed to a monocratic authority in the meantime. Having said that, so I think it's still valid what I will tell you about the powers of the DPA. And the first thing I have to confess, like Billy, we don't have the possibility to impose fines. This is the task of district administrative authorities, regional authorities, In general, it works, but of course, those authorities don't have so much experience in data protection, and sometimes they ask back to the authority, to the DPA, if the behavior of a person or something falls under the penal provision of the Data Protection Act or not. So I have some doubts if this is really the best procedure for dealing with this. Yeah? However, the DPA can issue binding decisions, for example, if there are complaints against controllers in the public area, but also if there are complaints against controllers in the private area, but only concerning the right of access in the private area. So, for example, if a firm violates the right of access, then there is a formal decision by the DPA, and then the firm is also, there can be an order to give access to data within a certain deadline. There are also some other areas where the DPA can take binding decisions. For example, in the notification procedure, the DPA can refuse registration of data applications. It can also give authorizations in transfer to third states. And also in the case, if there's an immediate danger to interests of secrecy of the data subject, it may prohibit the continuation of a data application by ruling. In other cases, so for example, if there are complaints in the private area, not dealing with the right of access, the Data Protection Authority has only the right to give recommendations. So it's a sort of ombudsman procedure. And then applications can be examined, and the DPA can issue recommendations. And if a recommendation is not obeyed, there are also some possibilities like bringing a criminal charge pursuant to the penal provisions of the Data Protection Act, or, for example, in case of severe transgressions by a private sector controller, the DPA can file a lawsuit before the competent court of law. Against all formal decisions, there's the possibility to lodge an appeal before the Federal Administrative Court, which is a completely new court, and it may be brought by any party, so either by the data subject or by the authority or the firm or the controller. Yeah? The question, how have data controllers complied with the decisions and regulations of the DPAs, can be answered, and it might be surprising for you that in most cases it was no problem. In most cases the binding decisions were followed and even recommendations were followed. In some rare cases an enforcement proceeding was necessary against firms in the private area, but in the past such proceedings were closed earlier because the controller gave access during the proceeding to the data subject. And also in a big number of procedures, the rightful state has already been established by the controller during the proceeding so that the DPA could close the proceeding earlier. Only in some rare cases there were problems with recommendations, and in this case it's really a problem because then the DPA cannot really do anything. Does it mean this high degree of compliance that everything is okay with data protection? I don't think so, because I think that controllers react if they get a letter from the DPA, an official letter, but there's a big gray zone where firms, for example, do not comply with data protection rules. And why is this the case? Because on the one hand, the sanctions are not sufficiently efficient, and on the other side, it's a lack of resources in the DPA. So what's the impact of the new regulation if it would come? Of course, it would be a big progress, and I agree to what Mr. Nemitz said yesterday in this point, that the DPAs would really have more competences, more powers, at least small DPAs with limited powers, as it is the Austrian DPA. And I think that's also harmonization is really necessary in this field. So each DPA would have the same powers as the other DPAs. One big progress would be the possibility to impose fines, but also the power to take binding decisions in the complete private area, also to deal with complaints lodged by an association, and there are a lot of other new powers like approving binding corporate rules. Of course, awareness raising, what we are still doing, it would also be an official task to obtain data breach notifications and so on. There's one point which I want to mention because it was also mentioned by Vice President Reding when she presented the regulation that every data subject shall have the right to lodge a complaint with the supervisory authority in any member state. So she mentioned the Austrian student who went directly to the Irish commissioner. In the meantime, he finished his studies, but he's still, I think, your client, and still your client. Such a person could go directly to the Austrian DPA, but of course, if we have the one-stop shop, we would forward it to the Irish commissioner also in the future. And I think one big challenge is the future cooperation between member states, between DPAs, especially also concerning enforcement, because at the moment it's working on an informal basis. The DPAs in the Article 29 group learned a lot from the past because we had some bad experience in this field, and afterwards, now in the last years, we have a good coordination and also coordinated enforcement activities in the Article 29 group, but of course on an informal basis. And in the future, the big challenge is that there would be an institutionalized procedure, but at the same time respecting the independence of each DPA. And I think this is the big challenge for the future, to find a solution for this new institutionalized procedure. Last, not least, I want to give an answer to your question. I was not asked, but I think a mixture of both would be the best. Of course, we all prefer strong authority, but in some situations, an ombudsman procedure might also be useful or might be sufficient. So I think a good combination from these possibilities would be a good solution for the future. Thank you.
Thank you very much, Eva, for that, and also for answering that last question. Ivan.
I would like to turn to the audience again. Eva mentioned that her former office doesn't have a power to impose fines. And some people say that imposing fines is an efficient means to enforce the data protection rules. Others say that it's absolutely inefficient because big companies can pay the fines very easily and everything remains the same. So I would like to ask your opinion. Who thinks that imposing fines is an efficient, a useful means in the toolbox of DPAs? Please raise your hands. Quite a few of you. Okay, thank you. And who think that that this is a useless thing, and inefficient? Some of you, please hands up if you agree with this. Yes, just a few. You seem to be in favor of having this tool, and I turn back to Eva. Do you think it would have been better to have a power to impose fines when you were in office?
Well, I'm convinced that it would be better because then firms, for example, enterprises in the private area would more comply with data protection rules because they are a little bit afraid for being condemned to pay fines. And I think it's another situation if there's a district administrative authority or if it's the data protection authority itself which imposes fines. I think this is more respected by the firms. Besides, we have it may be of interest that the future regulation would really change the whole Austrian system, because at the moment the administrative penalties which we can ask for it could not be as big as, for example, to condemn Google to pay 500,000 euro. That wouldn't be possible according to our law. So this would really be a revolution for us. Thank you.
Thank you.
Thank you. I think we're well in time. I would like to ask Eva maybe a short supplement on this. We've been talking about fines. How important or how important do you think inspection powers are? In the UK, we've had a situation in which, until very recently, the DPA did not have powers to go in unannounced and inspect premises. He now has powers to do this, but only with regard to the public sector and not the private sector. And previously, he didn't have powers really to level civil and monetary penalties of any seriousness. But considering inspection powers, how important is that as an adjunct of enforcement?
I also think that the inspection powers are very important, and the Austrian DPA, for example, has also the possibility to go directly to the controller to get all kind of information to operate data processing equipments and so on. But the big problem is that we don't have the resources in the DPA. So I think the powers are there, and it's important, because if enterprise has the feeling that maybe tomorrow the DPA stands in front of the door and wants to look at the data processings, they would, of course, behave in another manner than perhaps now. And this is also a question of resources of the DPAs, and there's really a lack of staff. Thank you.
Thanks very much. I'd like to call now on Sophie to present.
Okay, just maybe to frame a little bit my presentation, I wanted to explain a little bit mention what the EDPS is responsible for in terms of supervision of compliance. We're responsible for compliance with the data protection regulation, a specific instrument, which is Regulation 45/2001, for EU bodies, so that is the main EU institutions, like the familiar ones you know, the Parliament, the Council, the Commission, but also EU agencies throughout Europe. So that's our scope of supervision and enforcement. The EDPS is being granted with relatively strong powers of enforcement in its founding regulation. Again, we can't impose fines, and that's also maybe because of the specificity of our sector. We're supervising EU institutions and bodies, and we are EU institution bodies, so it would be like feeding in the same budget, which is the EU budget. So that maybe explains the reason why we cannot impose fines, but we can order the exercise of certain rights, we can ban a processing operation, we can warn or admonish a controller, we can also refer a matter to the court if necessary. And the court can then subsequently impose a fine if necessary. The EDPS has taken a view to have a layered approach to compliance and enforcement. And so we believe that compliance, of course, has to be ensured at different levels, starting with, of course, the responsibility of the EU institutions themselves to protect the fundamental rights and freedoms of data subjects. This is maybe a little bit the principle of accountability to a certain extent, which has already been embedded in Article 1 of the regulation. We also believe that the second step to the layered approach is the role of the data protection officer, the DPO. There's a legal obligation in the regulation to appoint at least one DPO in each institution and body. And we believe it's vital for a policy of accountability to have controllers benefiting from the internal expert advice of these DPOs. And to this extent, the EDPS has provided a lot of efforts to provide support to the work of the data protection officers in their bodies. We adopted in 2005 a position paper about the role of the DPO in ensuring effective compliance with the data protection regulation. We've also supported the DPO network. They've developed professional standards, and we fully supported that. And then third, so institutions, DPOs within the institutions, and of course the EDPS comes on top of that but we've chosen to have a selective, targeted approach to enforcement, with emphasis on those institutions and bodies that show clear lack of commitment or a poor compliance record. Our main policy, as defined in our strategic objective, is to promote what we call a data protection culture within the EU institutions, so that they are aware of what their obligations are and that they are accountable for complying with the data protection requirements. Data protection authorities can only enforce what they see. The challenge is to ensure compliance in practice for what we don't see. So in 2010, we adopted a compliance and enforcement policy where we decided not to adopt a punitive approach to enforcement, although, of course, where necessary, we will do so, and we have banned a processing operation, but rather to rely on good administrative cooperation. We believe that data protection is and has to be considered as part of good administration in the EU institutions. We also consider that enforcement without education, without educating, is not viable. I mean, controllers have to understand what data protection is about and why it's important to comply. And that's really been an important effort in our work, is to make them understand why it's important, what they have to comply with, and the importance of it. Constraints and opportunities in our work. What I would say that the fact that we're working in an interinstitutional context is probably an opportunity. It's our framework. We have 62 EU institutions and bodies, so it's quite limited. And we're in the presence of colleagues. We are ourselves a EU institution. We're also working in the public sector, which can be a challenge because, of course, in the public sector, data protection is not so much considered as a marketing asset. There's no client to satisfy, or at least not in quite a strict relation as in the private sector. I think the mandatory appointment of a DPO in all institutions and bodies can be seen as an opportunity. As mentioned before, they are key to a strong compliance mechanism. However, mandatory appointments of DPOs can also have a downside, to the extent that often we find that when it's mandatory to appoint a DPO, and this is particularly true in the smaller agencies, is that because they have limited staff, well, they just grab the first lawyer they can find in the corridor and appoint him as DPO, which in the end comes to either having a poorly trained DPO, or sometimes they're not given sufficient time to be able to perform their functions, and sometimes they lack support from senior management. And that's why I was saying we've put strong emphasis on providing support to the work of the data protection officers. In practice, how do we ensure compliance? Well, we do so in various ways, and I'll only highlight a few. Coming back to my point about promoting a data protection culture, well, how do we do this? This is maybe what the soft tools that Billy was referring to. We provide guidance to controllers and data protection officers. We do training sessions, organize workshops, seminars. We also promote dialogue with controllers. For example, we sometimes organize a meeting before we adopt a formal opinion to fully, for two reasons. A, to make sure that we fully understood the context in which they are working and their constraints, but also to get them on board and for them to be fully understand what we are recommending and why we're recommending it. It's very important that they understand what we will say in the formal opinion. We also have developed a compliance tool which, in the form of visits by the supervisor or the assistant supervisor in those bodies where the compliance mechanism is blocked. These are cases where we have very little information about the status of implementation of the regulations, so we decide not to perform an inspection. We do have inspection powers, but here we decide that we won't inspect because we're not really sure what to inspect, but rather to have a visit. And a visit is, as I was saying, a visit by the supervisor or assistant supervisor where they will meet with the top management of the agency or the institution. And this is crucial to the start and to the good result of the visit, is that if you can get top management on board, well then usually there's a trickle-down effect and we usually achieve very good results. The visit is always concluded with a roadmap where there's an agreement between the two parties about what are the main steps towards compliance. We've performed 14 visits since 2010, and we usually have found that it has unblocked the situation, and it preserves from stronger enforcement measures. As I said, we also perform inspections where we check reality, and then we draft a report with recommendations. And another exercise which we do is general stock-taking exercises, focusing on certain aspects that give a good indication of the progress made in implementation of the regulation. These reports are made public. The responses are displayed in comparative tables with set peer groups and with benchmarks set per group of institutions and agencies. The benchmarks are not fixed in abstract, but they're usually based on the results achieved in each group. And they enable comparison among peers, which is very interesting because very often we don't make any strong conclusions, but just by making it public and having the institutions look at their results versus the results of another comparable institution or agency in terms of size or types of data that they process, well, they reach their own conclusions, and very often it helps to get them to comply, or at least to improve their compliance record. We find in general that the results of these general monitoring exercises, which I'm just referring to, and the next one is just being finalized and will be published next week, demonstrate that in general we've achieved, or there's a good compliance level in most EU institutions and bodies. Notification rates, for example, have risen in general. They all have appointed a DPO, they've adopted implementing rules, and that gives us a fairly good indication that, well, compliance is improving. Also, a good indicator is the fact that we have never had to take an institution or an agency to court, even though in some cases we were close to doing so. But usually a visit or a meeting has helped to get the controller on board and into compliance mode. We find that pragmatism, dialogue, and a cooperative attitude often promotes compliance, and we believe this so much that it's actually been introduced into these values have been introduced into our rules of procedure. As to how the reform will influence the regulation, well, it's not sure yet when and how Regulation 45/2001, which is a specific instrument, will be modified. It's not sure whether it will be it will be integrated into the general instrument, or whether we will have a specific instrument. But what we are already doing is trying to integrate some of the principles of the reform into our supervision work. I referred earlier to the accountability principle, which we try to apply in practice. DPOs are already very much part of our landscape, and we work very closely with them, as I said. And the principle of privacy by design is often also very much integrated into some of our opinions. That's it.
Thank you very much, Sophie. Ivan, do you?
Yes. It's the EDPS has a very special mandate, and it's very interesting to hear how you make the data controllers comply within this not so small community with the data protection regulations. But previously, the previous European Data Protection Commissioner or supervisor issued positions or recommendations or kind of guidance to the rest of the EU, because we are under the same umbrella, on the notion of personal data, for example. Do you think that in the future, that depends on the future EDPS, will the office issue kind of guidance or in the field of enforcement, for example, or how to deal with the DPOs in other sectors for the national data protection agencies and regulators? Do you think that it will happen?
Well, I can only speak on my personal account. I mean, what I've been really focusing on here is our role in what we call the supervision and enforcement sector. I think what you're referring to is the other side of what the EDPS does, which is more legislative advice, where we provide opinions and we contribute to the work also of the Working Party 29. But So I think that the EDPS can only provide, I mean, if we were talking about supervision and what I've mentioned today, I mean, we have no authority on other DPAs, but as any other DPA, we can provide certain recommendations based on our experience. But again, I think that for certain things, for example, the appointment or the work that we've done with data protection officers, I think it is maybe interesting in that not so many member states, I mean, some do already have the DPOs in place, but not all member states have DPOs. So I think maybe it's interesting that we can, but not to give any,
Yes.
I mean, we have no authority. It's just in terms of sharing our experience with other DPAs. We're very much part of the DPA community, and we want to remain so.
Thank you. I would like to ask the last question to the audience before I give you the mic, and you will.
We have Bob Gellman still.
But
We have a fourth speaker still.
But before that.
Before that.
Yes, yes, of course. So the question is very brief. That sometimes DPAs are appointed by the government, and sometimes they are elected, generally by the parliament. Which model do you prefer? Please raise your hands if you agree with the parliamentary election model, if you prefer this one, as opposed to the other one. Thank you. Quite mixed results. And who is in favor of appointing the DPAs from the part of the government, let's say Prime Minister or from the executive branch? A bit smaller, a smaller proportion. We can discuss it later, but you are right. We have another speaker, and then after the final paper, you will have a chance to ask your own questions.
Thanks very much. Over to you, Bob.
Thank you. I want to tell a tale of two U.S. privacy enforcement agencies. I think many of you will be surprised to know that there is more than one. The Federal Trade Commission is not the only agency. The Department of Health and Human Services has an Office for Civil Rights, or OCR. OCR enforces the federal health, privacy, and security rules known as HIPAA. I won't explain what HIPAA is because it's not enlightening. The privacy rules themselves are about 10 years old, and the security rules are a few years less than that. So I'm going to tell you the record of OCR in conducting investigations. In 10 years, the agency has received approximately 80,000 complaints. Of these, 29,000 were investigated, the rest being outside the jurisdiction of the agency, and they found 19,700 violations, or approximately 2,000 a year. Now, there's a lot of controversy that I could raise with respect to that. The agency isn't perfect, but that's a big number. Now, for many years, the American business community, the Department of Commerce, and the FTC itself have loudly promoted the Commission as some sort of general-purpose privacy enforcement agency. The truth is that the FTC has jurisdiction over less than half of the U.S. economy. It has no jurisdiction over the transportation sector for the most part, federal, state, or local governments, nonprofits, telecommunications, insurance, and more. Its regulatory powers are narrowly constrained. So here's the record of Federal Trade Commission investigations for the last 10 years. How many complaints have they received? The answer is, we don't know. The Federal Trade Commission is a black box. How many has it investigated? The answer is, the Federal Trade Commission is a black box. They have brought approximately 100 formal complaints in the last 10 years. Now, these numbers are a little bit out of date. They brought about a dozen safe harbor cases this week. So I haven't updated numbers. And since 1997, when I compiled the statistics a little while ago, there were 153 cases reported on their website, approximately 10 a year. And to be generous, we can say perhaps 20 a year because they've been a little bit more active. So is the FTC truly an effective privacy enforcement agency? I think the comparison with OCR is telling, 2,000 a year versus 20 a year. Furthermore, if we add a denominator to these numbers, OCR, for the health sector, has about 10% of the U.S. economy. The FTC, roughly speaking, it's hard to judge, has about half the U.S. economy. So that if you put a denominator to the numbers, the FTC record is significantly infinitesimal. Now, I'm not arguing that the FTC is a bad agency. It's filled with smart, competent, well-intentioned people. It's just institutionally incapable of carrying out the function. And here's a telling story, something very recent. The Federal Communications Commission, or FCC, regulates telecommunication common carriers with respect to privacy. The telecommunications industry recently started a major campaign to take privacy jurisdiction away from the Federal Communications Commission and give it to the FTC. Now, does anybody think that an industry wants to move its oversight to a more effective regulator? I think the question answers itself. I've been a long-time observer of privacy. I've been working in this area for almost 40 years. Some things have changed in that period, some things haven't. One thing that hasn't changed is the major effort by the U.S. government to sell the story that America does privacy differently than Europe, but it does it just as well. This story was hatched during the Reagan administration in 1981 as part of what was a cynical effort to try and fool the international community and avoid international regulation of what was then called transborder data flow. This effort has continued unabated for 30 years, the same message, the same misrepresentation. 10 years ago, I gave a speech in Washington, and I said that if I had $1 for every time somebody from the American business community or the American government went to Europe and promoted the Federal Trade Commission as some great privacy regulator, I said I could fly everyone in the room to Paris for lunch. I said that if I had $1 for every case the Federal Trade Commission had, I couldn't buy myself lunch. The numbers have changed somewhat. On the other hand, today, at this moment, Paris is a lot closer than it was when I gave the speech from Washington. But I still think that the Commission is limited in what it can possibly do. I think privacy self-regulation in the United States has been a failure. It arises only when there is a threat of regulation, either by the Federal Trade Commission, and the threat from there is very remote because they don't have the authority to do so, or from the Congress. And the minute the heat is off, the minute the pressures for regulation disappear, self-regulatory programs also disappear. I want to make a couple of comments on things that have changed over these years that I've been doing privacy. Privacy is clearly a much bigger issue everywhere. I was a staff member in the U.S. House of Representatives for 17 years, from 1977 to 1994. It was very hard to sell privacy then. Only with the internet did the public understand some of the stakes in the privacy debate. There's been more attention. There have been more horror stories, which is a great motivator in passing legislation. What the U.S. tends to call the sectoral approach to privacy regulation is really the horror story approach. We get a horror story and we get a piece of legislation that covers some type of record or some type of record keeper. It's uncoordinated with every other piece of privacy legislation that we have, and it creates more and more problems as the borders between these laws begin to overlap. If I make a health insurance copayment at my doctor using a credit card, have I created a health record? Have I created an insurance record? Have I created a credit card record? They're all subject to different kinds of privacy regulation. I probably created all three kinds of records subject to overlapping rules. That's a major problem. And one of the consequences of this, I think, is that some of the bigger companies in the United States have finally recognized that there is value to some kind of broader privacy law so that you have more standard rules and you don't have these problems of different rules for different kinds of records. The pressures for that kind of law are not universal, and I think that it's very difficult to see how the U.S. could pass that kind of a law anytime soon. The internationalization of everything, really, in the modern world has made it harder for U.S. companies to address privacy in the old-fashioned way, and I think that's motivated some of them to look for better ways of doing things. And an increasing but still small number of American companies are trying to do the right thing and to address privacy in a way that's fair and even-handed and recognizes the interests of consumers. Winston Churchill once said, "The United States inevitably does the right thing after having exhausted every other alternative." I don't think we've exhausted every other alternative in the privacy space, but we are running out of bad options. I think the best hope for U.S. consumers doesn't come from our famously dysfunctional Congress. No one thinks anything is likely to happen anytime soon, but there will be an election this year, and there will be an election 2 years after that, and the Congress will change, and things will change. But if there's any hope for U.S. consumers in this area, I think it comes from the EU. If the European Union succeeds in advancing its privacy regime, then American consumers will be indirect beneficiaries in the same way that they have been beneficiaries from the EU directive. I'm not saying exactly what should be done, but a better privacy law, better privacy rules, better privacy enforcement in Europe will be beneficial in America. And I think it's a very important step toward making America pay attention to privacy in the same way that the rest of the world does. I'm not sure there's much else that's going to make a difference. Thank you.
Thank you very much, Bob, for a vintage performance. I'd like to ask Ivan now, and then I will have a very small intervention myself before we go to the audience. We still have about 10 minutes plus.
Could you help me to give the mic to the audience? So who would like to make a short, factual, provocative comment or question? Please reserve the longer comments for the personal discussions. Kaspar first.
Caspar Bowden. First of all, I'd just like to say how much I enjoyed Bob's contribution. Thank you very much. So my question is, what do the panel think about the possibility of creating an objective framework for benchmarking the performance of data protection authorities? If we look at the capacities, the staffing, the priorities of European data protection authorities, they're obviously very different. Data protection authorities tend to produce an annual report which, as it were, self-assesses their performance and priorities. But there doesn't seem to be any institution which has the role of checking. For example, how do they deal with grey area decisions? How do they make their decisions accessible? What kind of mechanisms in future can we expect from data protection authorities to show good faith in cooperation in the consistency mechanism and the data protection board? So I can see many difficulties in setting up such an objective benchmarking framework, but is this something that the panel thinks is welcome or necessary or could be achieved?
Thank you. Who would like to answer?
I'm happy to answer that question, at least for me. Yes, I would welcome such an approach. I think it is desirable that there be clear benchmarking of our performance. I think it would become even more essential under the regulation, under the one-stop shop consistency mechanism, where DPAs are going to have to rely on one another in terms of enforcement, in terms of the residents of other member states. I don't think it's quite right to say nothing has been done. Some useful work has been done by the Fundamental Rights Agency of a comparative nature, and I know it's currently engaged in another exercise in relation to the resources of DPAs. So I think there is a basis to build on. I would also point out that the countries that joined the European Union more recently were actually subjected to a benchmarking exercise, a peer review type operation, which is something you'll find particularly in the OECD, for example. So I think there are plenty of models there. I think such an approach is essential, in fact, particularly under the new regulatory approach, and it's an approach I would very much welcome.
May I turn this question into more concrete? How can you measure the efficiency of enforcement by the decline of complaints or the increase of the number of complaints because people are more aware of the facts? So how can you measure in practice?
I agree with great difficulty because obviously the tendency when you have such benchmarking is to measure what can be measured. So you're dealing with statistics about complaints, about, I don't know, time taken to deal with a complaint, publication, that type of thing. However, I think there are most, or certainly our own DPA included, do carry out fairly regular public surveys in terms of perceptions, at least, of data protection. And there have been other surveys carried out too, I think, particularly among organizations as to the extent of compliance, because I think ultimately our effectiveness must be judged by the level of compliance with the law in our member states. Ideally going beyond, but at least that there should be compliance. So I think that there certainly is scope for benchmarking. I don't pretend it's easy.
Lunch break will start in 10 minutes.
10 minutes, that's much better than the 5 minutes bell.
Thank you very much. I agree with Billy that it's necessary to have such a formal cooperation in the future. Where I have some doubts is if the regulation really would help to solve the situation of the lack of resources, because the provision in the regulation doesn't say very much, not more than it's the case at the moment, that it's necessary to have the task, which the staff which we need for the tasks, but there's no number, there's no nobody knows how many people this would be. And I remember that we had to deal with questionnaires estimating how many people will, for the new tasks, how many people we would need in the future. And I remember that, for example, the Austrian DPA has 21 full-time posts, and for the future we would need even 20 more people. And this is not exaggerated, I think, because there are so many tasks which would be added to the tasks of the DPA. And so I'm not sure that this would be solved by the new regulation. I have really some doubts, because this is, of course, a task of the member state. What you said about how can you, are there any measures to deal with the effectiveness of a DPA? I think this is very difficult because perhaps one measure is the length of the procedure, maybe.
Yes,
Thank
that's
you.
very important. Charles would like to add something?
Just a tailpiece as an academic, and I can't resist that. Some years ago, Colin Bennett and I wrote a book called Governing Privacy, which some of you may know. And we devoted a whole section to the question of how the effectiveness of data protection can be measured. And we disaggregated that into a number of categories, and we found it was very difficult and very slippery to do that. But more recently, there have been other academic efforts to look at DPAs and see what they do and how they do it. And there's a member of the audience here, Philip Schutz, who's done some interesting work on that as well in Germany. But what I would say is that if there is a move to get a benchmark kind of thing, or to take the idea of benchmarking seriously, I think there is a definite academic input that could be made into this, and it shouldn't be left to management consultants and DPAs themselves or other people who will put glossy covers on the report.
Okay, thank you. Before you would add something else to this question, I would turn to the audience. Other questions, short, provocative comments are welcome. 1, 2.
Could I ask Robert, as a dispassionate observer, to help me? I can't see the point of the EDPS at the moment. If it's only looking after 62 institutions or so, why can't they be divvied out among the existing data protection regulators of the member states, which they got their headquarters in? Are we talking about a waste of resources, or do you think there's something special that the EDPS can do that local regulators can't?
Okay, it's very concrete. Could you...
Did you really want me to address that? I don't think I'm the right person to comment on that. I don't think I know enough to answer that question. So I'm just too remote an observer. Sorry.
Okay. do you have the mic? Who has? Philip?
So yeah, my name is Philipp Schütz. I'm working for the Fraunhofer ISI. I'm a political scientist as Charles Raab, and I'm doing also research, comparative research on data protection authorities. And I have to admit, I'm quite amazed that we still talk about the question whether we need sanctioning powers or not. And also in my research, every data protection authority I was talking about really envisaged this new instrument from the General Data Protection Regulation as a new chance to actually really regulate companies, but also public authorities. So companies such as Google and Facebook systematically violate data protection law, and they have to because their business models are in sharp contrast to central data protection principles such as data minimization, for example. So there's a deep-rooted conflict of interest when it comes to the business models of these companies. And that's why, in my opinion, we definitely need harsh sanctioning powers to enforce compliance with the law we have in Europe. And yeah, the other thing about appointment and because I'm also doing research on appointment procedures and election procedures, I mean, it just seems to me absurd if an entity that should be actually regulated by data protection authorities appoints the same, right? So we definitely also need there much more parliamentary influence, or also already in the nomination process, not only in the appointment or election processes. Thanks.
Thank you. The last question over there. We collect the last contributions. And the last few minutes is...
Stephen Gardner, I'm a journalist with Bloomberg BNA. This is a question mainly for Billy, which is, under the new regulation, it seems to imply that you would have to take in enforcement a more punitive approach, perhaps a more standoffish approach to companies rather than the cooperative approach that you described earlier. So I wondered if you foresee a cultural shift there that you're going to have to manage, and if that causes any issues for you.
Okay, I suppose I'll answer first. Taking the first question, I think there's first of all a mistake in equating sanctions with fines. I thought I made clear in my presentation, in fact, the clear enforcement power I want is the power to order processing to stop, which I already have. I think fines certainly are a useful addition to the toolbox, but I would put it to you that they're neither a sufficient nor a necessary part of achieving compliance. And there's a very recent example, I won't name, you know it, where a particular company has been fined, but it has not changed its behavior. So I think that is my answer to that point. On the second one about the appointment of the Data Protection Authority, I agree it should be as objective a process as possible. And how that operates can be different because, for example, Parliament could operate on a purely political level, government could operate similarly, so you need something that's effective. I think you hit the point in terms of screening mechanisms to make sure that somebody who is competent is actually appointed to the job. In terms of the question about change of approach, yes and no, I think, would be the answer. The approach we have at present essentially is do it our way and everything is fine. Fail to do so and you will be very sorry. So I don't envisage any change, frankly, from that approach, which is the approach at present. I think it would be a mistake if fining were to be automatic. In other words, that whatever happens, even for a first offence, you have to fine somebody. So I think if the fining power is used intelligently, it will be an addition, certainly in our case, to an already extensive toolbox, which we use and deploy as required in order to ensure, as a minimum, compliance with the law, but ideally going beyond that to best practice.
Well, I think, would you like to have a short intervention, or Bob?
Well,
Yes,
just make a comment. I spoke earlier about the Office of Civil Rights enforcing health privacy rules. For the first several years of its activities, it imposed no fines on anyone. That's part of the controversy of the office. And its view was, we want to encourage compliance. We want to teach people to do the right thing. And roughly speaking, I think that was the right approach. In more recent years, they started to impose fines. In one case, $4 million. In other cases, there have been other million-dollar fines. Whether those fines are the right amount or not, is anybody's judgment. But there's a place for different kinds of approaches at different times. It's easy to draw lines when you have a new law. It's a harder thing when you have an existing law that's been around for some years.
Okay, thank you very much. The noises and smells coming from the other side of the hall are very attractive, so it's time to give back just for a two-sentence closing of the session to the chair of the panel.
I think this has been a very interesting exploration of a very important area, and I'd like to thank the audience for voting. We haven't recorded how you voted or whether you voted, so don't worry. But I think that was really very illustrative of the mood, in a sense. I think also what we've heard from the panelists, both those who are in charge of doing enforcement and so on, telling what they do and what the likelihood is of doing it better or differently in the future, I think has been quite illuminating, and I think particularly because they related the question of enforcement to many other aspects of the operations of DPAs. And so, in a sense, we got a kind of more rounded view of the contexts within which DPAs do their enforcement work, which is not the only role that they perform. And I think also it has been very nice to hear the view from across the Atlantic, or I should say from the USA, because in Canada I think things are tolerably better, or at least different from the way they are in my native country. So I want to thank all of the panelists very much. I want to thank also particularly Ivan Szekely, whom I failed to introduce and show his credentials up there, but it's been a great pleasure working with him this third year, as in previous years, to put together a panel on DPAs. And thank you all, and can we thank the panelists in the usual manner.